Welcome back to the deep dive. Today we are opening up a file that really every single person listening to this needs to understand. I don't care if you're a law student, a real estate developer, or, just someone nervous about buying a house.
It's a universal problem.
It is. We're talking about the escape hatch in a contract. You know the scenario. A client wants to buy a piece of land, but they're nervous. They want to lock up the deal, but they also want a back door, a way out if things get too complicated or too expensive. So they insert a clause. They say the deal is subject to their own satisfaction with a development plan.
It's the classic subject to satisfaction clause.
Yeah.
And on paper, it looks like a safety net. It feels like you have all the control.
Exactly. But here's the core question we are tackling today. Can a buyer use that clause to walk away from a deal just because they change their mind about the costs? Or does the law, force them to stick to the bargain? To get to the bottom of that, we're analyzing a landmark case from the Supreme Court of Oregon, Western Hills v. Pfau.
This case is the gold standard. It really is. Because it tests the boundary between a legitimate condition in the contract and, well, just plain old buyer's remorse. And to really understand what happened in Western Hills, we need to dissect three specific legal doctrines.
Okay, lay it out for us. What's the roadmap for this analysis?
To solve this, we have to look at the machinery of the contract. First, we have to look at conditions precedent, and specifically the implied duty to make a reasonable effort.
Okay.
Second, we have to analyze satisfaction clauses themselves. We need to distinguish between personal taste, which is subjective, and utility, which is objective. And third, and this is the real clincher for our main case, we have to look at the good faith standard, specifically as it relates to known circumstances.
Okay, let's unpack that. I want to start with that first concept, the duty of effort. I think a lot of people assume that if a contract is subject to something like getting a loan, if that thing doesn't happen, the deal is dead, they're off the hook. But you're saying it's not that simple, not that passive.
Absolutely not. The general rule comes from a case called Anaheim-Kunze-Fielcom. And the court there established a really critical baseline. When an agreement have a condition, in that case it was contingent on obtaining a loan, it imposes an implied duty on the buyer to make a reasonable effort to get that condition met.
So implied means it's not written down, but the court just assumes it's there.
Correct. The law assumes you intend to honor your side of the bargain. If the condition is getting a loan, you have to actually go to the bank and apply. You can't just sit on your hands and then rely on the non-occurrence of a condition you never even tried to pursue.
That makes perfect sense. You can't sabotage your own deal. Okay, let's move to the second concept, which is where it gets really interesting for me. Satisfaction. We see these clauses all the time where performance has to be satisfactory to one party. I'll pay you if I'm satisfied. To me, that sounds like a blank check to say no. Is it?
It is not a blank check.
Yeah.
We look to the rule from Johnson v. School District Number 12. The court divides these clauses into two very distinct categories.
And what are those two categories?
The first category is for things involving taste, fancy, or personal judgment. The classic example is a commissioned portrait. If I hire you to paint my portrait, and the contract says I only pay if I am satisfied, then I am the sole judge. It's purely subjective. The only standard the law holds me to is good faith.
Okay. And the second one?
The second is for things of utility, fitness, or value. So think of mechanical work or installing a new furnace. This is measured against an objective standard. The law asks, would a reasonable person be satisfied? In those cases, the work just needs to be reasonably satisfactory.
So art is subjective, mechanics are objective. That seems pretty clean. But let's muddy the waters a bit. I've got a hypothetical for you. Say I have a contract to buy land and it's subject to obtaining leases satisfactory to the purchaser. Now, leases are about money. That feels like utility. Does that fall under the reasonable person standard?
You'd think so, wouldn't you? But the courts say no. This comes from a great case, Matei v. Hopper, which analyzed that exact situation. Even though leases are commercial, the court held that they involve too many complex factors. The mix of tenants, the length of the lease, creditworthiness. It's just too complicated for a simple, reasonable man standard.
So the court actually put it in the taste and judgment category.
Exactly. The sheer number of factors makes it subjective. But, and this is the key distinction, even though it's subjective, the buyer's dissatisfaction must still be bona fide. It has to be real.
This distinction between real and, fake dissatisfaction seems incredibly hard to prove. Let's set up a scenario to really nail this down before we get to the main case.
Leave it.
Okay, I hire you to paint my portrait. I'm the buyer, you're the artist. The contract says I only pay if I am satisfied. I sit for you, you do the work, you present it. Scenario A, I don't even look at the painting. I just wave you away and say I'm dissatisfied because I just realized I'd rather spend the money on a vacation. Am I in the clear?
No. In scenario A, you're in breach. That is what the law calls feigned dissatisfaction. You aren't dissatisfied with the art. You're just dissatisfied with spending the money. You refuse to even look at the performance. That is a classic example of bad faith.
Okay, let's try scenario B. I look at the painting, I study it, and I say, you know what? I am dissatisfied because this painting, it shows that I have a very large nose, and I hate my nose. I'm not paying.
Now, this is where it gets subtle. In scenario B, we have what's called a pre-existing knowledge problem. If you had a large nose when you sat down in that chair to be painted, you cannot use that as grounds for dissatisfaction. The rule is you can't base dissatisfaction on circumstances that were known to you at the time you made the contract. You knew about your nose, the painting is accurate, your dissatisfaction is with your face, not with the artist's work.
That is a brilliant distinction. You can't hire someone to do a job knowing the constraints and then claim you're unhappy with them for working within those exact constraints.
Precisely. If you know the circumstances going in, you are what we call stopped from using them as an excuse to get out.
Okay, that nose example is actually perfect. It leads us directly into our main event. Let's analyze Western Hills v. Pfau. First, what are the legally dispositive facts?
All right. The plaintiff, Western Hills, listed about 286 acres in Yamhill County. The defendants were a group of investors led by a man named Pfau. They agreed to buy the land through a property exchange plus some cash. But here is the key clause. The closing was subject to the purchasers negotiating with the city of McMinnville for a planned development satisfactory to both parties within 90 days.
So the whole deal hinged on getting a development plan that they like and that the city would approve. What happened?
Well, the conflict arose when the defendants made some preliminary proposals to the City Planning Commission, and the city actually reacted favorably. But then the defendants abandoned the application. They just stopped trying.
Why? What was their reason for just walking away?
Their reason was that they realized the city sewers weren't available right away. They would have to build a private sewage system, and that would make the deal too expensive. But, and this is the crucial detail, the defendants knew the city sewers were unavailable when they signed the contract. They'd even deleted a specific subject to sewer development clause from an earlier draft.
Wow, okay. And what was the core legal issue?
The issue is this. Can a purchaser use a satisfaction clause about a development plan to get out of a contract when they abandon the effort because of an expense, the sewer systems, that they knew about and contemplated when they signed the deal?
What rule of law did the court apply? Can you state the full black-letter rule and break it down into its testable elements for us?
Sure. The court basically synthesized the rules we've been talking about. The final rule has 3 distinct elements. First, the duty of reasonable effort. The party who benefits from the condition has to use reasonable diligence to try and fulfill it. That's from Anaheim.
Okay, that's element 1.
Second, the categorization of satisfaction. You have to determine if the clause involves taste and judgment, making it subjective, or utility, making it objective. That's from Johnson and Matai. And third, the good faith known circumstance limitation. If the standard is subjective, the dissatisfaction must be bona fide and cannot be based on circumstances that were known or anticipated at the time of contracting.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply that first element, the duty of reasonable effort?
So the sub-issue there was, did Pfau and his partners actually make a reasonable effort to get the city's approval? And the sub-rule is that just abandoning the effort without a good reason is a breach of that implied duty. When the court applied this, it noted that the City Planning Commission had reacted favorably. There was no sign the plan would be rejected, yet Pfau had just stopped. So the court's conclusion on that element was no, they failed their duty.
Understood. Now, what about the second element, categorization of satisfaction?
Here, the sub-issue was whether a satisfactory plan development is a matter of taste or utility. The sub-rule, drawing from Mattei, is that if there's no objective test to see if a reasonable person would be satisfied, it falls under personal judgment. And the court found that, well, there's no objective way to measure a development plan, it requires personal judgment. So the conclusion for this element was that this is a subjective personal judgment clause. The standard is good faith. not reasonableness.
Now for the critical turn, how did the court apply that third element, the good faith known circumstance limitation?
This is where it all came together. The sub-issue was Pfau's dissatisfaction really in good faith? And the sub-rule is that a person can't claim dissatisfaction based on expenses or circumstances they already knew about. The dissatisfaction has to be with the plan itself, not the overall financial bargain.
And the application.
The application was devastating for Pfau. He claimed the development was unsatisfactory because of the sewer expense. But the evidence clearly showed he knew the sewers were unavailable from the very beginning. He'd even deleted that clause about it. So he was trying to use the satisfaction clause to escape a bad bargain, not because the city actually rejected his plan, the court's conclusion. The dissatisfaction was not in good faith. It was just a pretense to avoid a known cost.
And after analyzing all the elements, what was the court's final conclusion?
The Supreme Court of Oregon affirmed the trial court's decision. Because the defendants failed to use reasonable diligence and then tried to use the satisfaction clause to escape a known expense, they were not excused from the contract. Western Hills was entitled to specific performance. The court ordered them to buy the land.
That is a definitive outcome. So let's zoom out. For our listeners using this to prep for an exam or even to manage their own contracts, how do we synthesize all this?
Okay, let's put it into a diagnostic checklist. 4 steps. Step 1, spot the condition. Look for that subject to language. It's your first flag.
Step 1, find the flag.
Exactly. Step 2, check for effort. Did the party actually try to fulfill the condition? If they just abandoned it without a clear rejection from the other side, they've likely breached their implied duty.
Got it.
Step 3, classify the satisfaction. Is it art, taste, or judgment? That's a subjective standard, so you only look for good faith. Is it utility or mechanical fitness? That's an objective standard, so you ask what a reasonable person would think.
And then the final step.
Step 4, the known fact filter. This is the big one. If it's a subjective standard, you have to ask, is the reason for their dissatisfaction something they knew about when they signed the contract? If the answer is yes, their claim of dissatisfaction is invalid. They're bound to the contract.
That summary is perfect. The big takeaway here is you can't use a satisfaction clause as a trapdoor to escape a deal just because you realized it's going to be expensive, especially if you knew the price tag going in.
Precisely. It's not an escape hatch for buyer's remorse.
Before we go, here's a final provocative thought for you to consider. What if Pfau had actually submitted the plan and the city had formally rejected it because of the sewers? Would the result have been different? Or was he doomed the moment he signed a contract knowing that key piece of infrastructure was missing? It really makes you wonder if procedure matters more than the problem itself.
That's the question that keeps contract lawyers up at night.
Thanks for joining us on this deep dive. We'll see you next time.